The final matter to come before the court today is in re TP. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, please let me know, as I am keeping the clock this morning and can keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. My name is Shubhra Agarwal and I represent Christine Patterson, the appellant in this case, and I would like to reserve 3 minutes for rebuttal. And I'd like to briefly touch on the facts in this case before I proceed to my arguments. Children's Services filed a complaint alleging TP to be a dependent child in July of 2013. TP was then later adjudicated to be a dependent child. About 6.5 months later, in February 2014, Children's Services filed a motion for permanent custody. At the permanent custody hearing in July of 2014, Children's Services withdrew their motion for permanent custody, and a 6-month extension was granted to allow them to amend the case plan to include mother and add objectives for the mother on the case plan. Mother then filed a motion to dismiss the complaint based upon the recent case in re SR. That motion to dismiss was denied by the trial court, and in denying the motion to dismiss, the trial court also held that Children's Services was not required to make reasonable efforts to reunify the child and the mother. So I would like to address my assignment of errors number 2 and 3 first. When the juvenile court decided that CSP was not required to make reasonable efforts to reunify the mother with the child, the court held that Revised Code 2151.419A2 authorizes the trial court to relieve the agency of any obligation to provide reasonable efforts.
Can I ask you a question?
Yes.
Why is this a unaccountable order?
Your Honor, this case is identical to In re ZH, I believe, where this court had held a motion to dismiss the complaint is a final appealable order because it does impact substantial rights where the child could be in temporary custody, and the adjudication and disposition may not be reviewed if the motion to dismiss was denied.
So the point is that after the, so you file a motion to dismiss, and then the court rules on that, and because there may not be a permanent custody.
Correct. And it is a jurisdictional argument which could be raised at any point in time, so.
I understand. Okay, go ahead. I'll think about it some more. Probably bother you again. So go ahead.
So, the juvenile court held 2151.419A2 authorizes the trial court to...
Excuse me.
Yes.
You're running all these numbers so fast that it's hard for me to immediately understand what it says. If you could just say the statute that X, Y, and Z, it would be helpful.
Yes, Your Honor. The juvenile court held that the statute 2151.419A2 authorizes the trial court to relieve the agency of its obligation to make reasonable reunification efforts.
Okay, what in the statute says that?
There are 5 exceptions that are listed there, which include if the parent has been convicted of certain offenses, one of them being child endangering, and then there's other...
And you challenge that, why?
There was no evidence presented throughout the case.
On any of the 5
Correct.
exceptions?
Yes.
Okay.
Because that statute does specifically say that if a parent is convicted for child endangering pursuant to 2119.22B2, then the court has the authority of relieving Children's Services of making reasonable efforts. However, the judgment entry of conviction that was admitted into evidence at the adjudication, and I did attach that to my brief as well, does not list what section of child endangering Ms. Patterson pled to. In fact, I've looked at the indictment and that's not part of the record. She was not even indicted with that section. But we were not allowed to present that evidence because the court on its own granted a bypass when it was not requested. This case was not scheduled for a bypass hearing, so I was not able to present any evidence that Ms. Patterson was even charged, leave alone convicted, or pled guilty to the child endangering as specifically laid out in the statute of 2151.419A2. So that is why Mother is challenging that the court should not have granted a bypass without it being requested on its own, without a hearing, and without giving her an opportunity to even address that she was not convicted of any of the offenses that are listed in that statute. Then I would like to head to my first assignment of error, which Mother is alleging that the trial court committed reversible error in denying her motion to dismiss the complaint. As I stated earlier, CSB filed a motion for permanent custody about 6.5 months into the case. It then withdrew. Father, at the permanent custody hearing, did relinquish his parental rights, and then after that, CSB withdrew the motion for permanent custody, and a 6-month extension was granted based upon the recent case of Inri SR, where Mother was not included on the case plan, and there was no objectives for her to do. Although throughout the case, Mother had, during hearings, brought up that she was requesting there be objectives for her to be completed on the case plan. The CSB is required to maintain a case plan in order to help reunify the family, which in this case, there was a case plan filed, however, Mother was never, there was no objectives for Mother on the case plan. Mother did agree that the child's basic needs need to be met, but she was objecting to adoption being the reunification, or the goal of the case plan. So, in July of 2014, a year into the case, CSB did amend the case plan to include Mother on the case plan. And that is when Mother had filed a motion to dismiss, because Mother had been denied any statutory time frame to reunify with the child. Because the statute allows...
Was she given more time?
A 6-month extension was granted in July of last year. However, Mother's argument is that if she is given the statutory 2 years after the amendment, then the child has been in temporary custody for 3 years at the point, which is again against the time limit allowed by the statute. And at that point, does Father also get 3 years to reunify with this child when she's only getting 2? And Mother is arguing that CSB has violated her right as well as the child's statutory right to reunification. Because, again, Juvenile Rule 34A requires that a dispositional hearing be held within 90 days of filing of the complaint. And at the dispositional hearing, a valid case plan needs to be adopted. Mother's arguing that the valid case plan was not adopted because she was not, again, pursuant to Inri SR, she was not on the case plan. And so a new dispositional hearing needs to be held, which is beyond the 90 days. So Mother believes that trial court committed reversible error in denying her motion to dismiss based on that as well.
Is that a kind of an either-or proposition as it relates to the prior argument that she didn't, because she wasn't added to the case plan? Is that kind of a one way or the other? But these two things are mutually exclusive. Does that question make sense?
I'm not sure I understand the question.
Okay. So the argument is, look, she didn't get the statutory amount of time because she wasn't even added to the case plan until they requested the 6-month extension. So when we count back time periods, we don't have enough time there. The disposition hearing, the argument that they need to have another dispositional hearing after she was added to the case plan.
Correct. Well, my argument is Juvenile Rule 34A requires a dispositional hearing be held within 90 days of filing of the complaint. At that hearing, the court has to adopt a valid case plan. However, since the case plan that was adopted is not valid, the dispositional hearing is not valid. And so we need to have another dispositional hearing, which again is beyond the 90 days that's allotted by the statute.
But if they had another dispositional hearing beyond the 90 days, would you not be arguing that the complaint should be dismissed because the dispositional hearing happened?
That is exactly what I'm arguing, yes. That is part of the motion to dismiss that I was arguing.
Okay.
I believe the only remedy is to grant the motion to dismiss, and if CSB at that point wishes to refile, they can always refile and do this over again.
Okay.
And if there's no other questions, I would rest my brief.
May it please the court, Kevin DiMartino on behalf of Summit County Children's Services, the appellee in this matter. We are asking that this court affirm the decision of the trial court because the trial court did not err in dismissing mother's motion to dismiss and did not commit plain error by finding that the agency engaged in, did not have to engage in reasonable efforts towards reunification.
Do you agree it's the final appeal order?
Based on the case law that's come out of this district, I do believe that it's a final appealable order because if the agency did not file for permanent custody, then there would be no avenue for this court to review the decision with regard to the adjudication. I don't believe that the issue of reasonable efforts, that finding is the final appealable order because the court can go back. This case is going to go back either way, and the court can still make a finding with regard to that. I mean, the issue that's really before the court that I believe is the final appealable order is the motion to dismiss, and only the motion to dismiss. I don't believe there's any.
Because, you know, as I asked your opposing counsel, I was trying to piece this all together, and she cited DH, and DH was a lot different than this case, obviously. You know, that was one where the parent wasn't involved from the very start, and they
Right.
got put notice and couldn't appeal the adjudication, couldn't do anything.
Right.
Which, like I said, is completely different than this situation.
Right. I do, and this court could limit that decision in this case, but I do believe that the language in that case is probably broad enough to make an argument that it would be a final appealable order. The way I read it, I wouldn't disagree with the way that
So
case is.
anytime you file a motion to dismiss, you can file the motion to dismiss, it's going to be immediately available.
I would disagree with that. I do believe that there is an argument to be made based on the case law that if an adjudication, you file a motion to dismiss the adjudication based on the same argument, which is SR being attempts to overextend SR, which I've seen, I couldn't tell you how many times, and the facts are not on point. SR was very, very factually specific. That father was not on the case plan, should have been on the case plan. It was very, very, very narrow, limited to specifically those cases, and over again, we're seeing, for whatever reason, mother wasn't on the case plan. In this case, she was incarcerated, denied judicial release, agreed, she was served, she agreed to the case plan, and then as soon as there's an indication that we're going to go ahead and amend the case plan to give you some time to do some objectives, then it's, well, dismiss. Oh, and then as soon as you, if you don't agree with my motion to dismiss, then you have to say that the disposition was somehow void because the case plan that you adopted, which I agreed to, somehow rendered the disposition as if it never happened, and therefore now we're outside the 90 days, so you have to dismiss the case, but go ahead and refile. And you know, if we refile, it would be this argument that you already had your chance after 2 years, and this thing on and on. If you're worried about the best interest of the child, and your argument is they've been in the custody of the agency for too long, why would you ever argue that the agency should dismiss and start another 2-year period?
Well, you also have the issue though of appealing, which all the time that lapses too.
Right.
If they're all final appealable orders.
That's true too. There are a lot of issues with regards to that. I would argue, and I believe I argued in that case, that this issue could be reviewed later. The court, it is factually distinguishable, and I would ask the court to limit to that. But I do believe that this case would be the case to do it. I think that she still had, properly had it before us, and the way the case law is, I think that in this case, she probably is okay to say it's a final appealable order, but this court could limit it for future cases, if that makes sense. I mean, I would ask the court to limit the holding in SR and ZH. We have had a number of different procedural issues because of those cases and because of folks trying to have the trial court extend those cases completely beyond the factual pattern that was in those cases and beyond what this court's holding was. So I would argue that the court did not make a mistake in denying mother's motion to dismiss. This case is factually distinguishable, procedurally distinguishable from SR. A mother was served in this case, but there was reasons in the journal entry as to why mother was not on the case plan, or agreed to that case plan. And then the agency did later add objections for mother onto the case plan, which shortly after a 6-month extension was granted. And rather than trying to work those case plan objectives, mother immediately filed her motion to dismiss, attempting to argue that this case was in line with SR, which the agency would disagree with. With regard to the reasonable efforts, with regard to that particular objective, the agency would argue that that part of it was not a final appealable order, and if it was, that there have been other findings in the record in this case where the magistrate did find that the agency engaged in reasonable efforts. And even if the court was to just strictly look at the journal entry in this case, the court found that one of the exceptions applied where there was a finding of criminal violence act that the parent committed, and cites to this section, and Ms. Agarwal cited to 2151-419A2. The court does not specifically cite to 291922B, which is child endangering, but the journal entry does cite that mother pled guilty to criminal child endangering, but it does not have the section number. However, that would have been something that mother could have gotten into the record if that was truly the wrong section number, if it was 291922 and it wasn't subsection B. There's nothing in the record to show that the trial court erred in the finding. What is in the record is that mother pled guilty to child endangering with regard to these children, this child. And again, I would ask this court to take this opportunity to narrow the precedent for SR and ZH so that we can eliminate some of these appeals that are trying to, anytime a parent is not on a case plan, even if they agreed to not being on a case plan because they were incarcerated or something else, to immediately move to dismiss a case if they weren't on the case plan when they agreed to it, or if there's an amendment to include them. There's no reason to dismiss a case when this parent is given the opportunity after they submitted that they didn't want an opportunity to be on the case plan, and then they're given the opportunity to do so, and instead they move to dismiss. It really makes it very, very difficult for the agency to provide good care to these children, and it doesn't in any way, shape, or form allow for these children to move on and find permanent, stable placement. They end up kind of stuck in limbo, and certainly in custody of the agency for longer than they need to be.
When you say, and I understand the facts and circumstances of SR and ZH, but when you say when a parent's not on the case plan as it relates to maybe a long-term incarceration and so on and so forth, when you say not on the case plan, what does that mean?
There's no objectives for the mother. Sorry, I should have clarified that. This mother was listed on the case plan. There were just no objectives for her. The objectives only said that the child would be taken care of, basic needs would be met. But there was nothing specific for mother to do because she was incarcerated. So there was no objective for mother to obviously provide stable housing or to engage in any type of counseling. And she had agreed to that.
She had agreed to the absence of those in the case plan?
Correct.
Now, would it have been possible with her in prison for objectives such as letters to the child and other non-personal contact objectives, and to clarify that there was something she could be doing? Just because she was incarcerated, she wasn't cut out of any opportunity to maintain that relationship.
Correct. She was not cut out of anything. She just was not given any requirements that she would have to do to complete, so that when we got to the point of a sunset, would we say that she worked to remedy those conditions. And in this case, I don't know whether letters were sent or not, but I do know that there was an indication by the agency that mom had prior physical abuse and prior sexual abuse indications. So I don't know if she would have been permitted to write letters or not if she had asked.
But it seems that the general practice is if somebody is incarcerated, that's the end of any opportunity to maintain contact. There's nothing in the dispositional orders that suggests that mother, notwithstanding she's in prison, can have these objectives. Now, are you saying that she must initiate that,
No, I'm saying that usually what they say is, I have these objectives, and in order to remedy the conditions that brought the child in, I have to complete these objectives. So their argument is, if you didn't give me any objectives, how could I do anything to get my child back? So her argument basically is, you didn't even give me a chance because I had no objectives. But she had agreed that she was in prison, she was going to...
Well, okay, that's another issue.
Right.
I'm probably just asking out of procedure and further cases.
Oh, you mean just in general, how is an incarcerated parent?
Why do these orders not have something that takes into consideration the fact that a parent is in prison? Now, whether she's in prison or for 6 months or 10 years, it will make a difference, I think, to what might be recommended.
Right.
But if there's nothing addressed that a incarcerated prisoner can reasonably do, that gives me just some concern.
I do understand what the court is saying. I do. If there was something, perhaps, if this mother was going to be able to get out of prison prior to the 2 years, the sunset period, then I would argue the agency should have included something, perhaps, whether it's anger management or whatever else.
I don't know what the terms of her prison
Right.
were, whether she could get early release or anything like that.
Right, and it's in the record that she was denied judicial release, so we knew she was, so she was going to be in for a significant enough period of time that it would not have necessarily mattered. But I do believe that when there is some type of an option for parents to do that in prison that would be helpful, and they want to do those things, they are included in the case plan.
Well, I mean, just as a practical matter, and we're putting you on the spot here as it relates to other things that may or may not be a part of this case. But what would be the practice point of saying mother has to maintain stable housing, and then no, she couldn't because she was in, and she can agree, I don't think I would have been able to do that, but if at the beginning, at the front end of it, if it's never a requirement, even if we believe at the time there's no way she's going to be able to comply, what would be the problem putting that in there? Is it just the modem of proof necessary at the time when the motion for permanent custody occurs, or the motion for legal custody?
I believe so, and at that point, mother would, probably, there could be a finding of abandonment or anything else too at that point. I don't know, there just is probably no requirement to put on there that mother obtain and maintain housing, because if that's on there, then we have an obligation to provide services to mother to be able to meet the objectives. And how can we help mother obtain and maintain stable housing when we know she's in prison? Well, then the next thing will be, well, what did you do for me while I was in prison to help me obtain and maintain housing? And there's absolutely nothing the agency could do. So that would just open up a whole other can of worms, I believe.
What does the agency do with a parent who is in prison? They look to relatives.
They look to relatives, but they also, for short-term prison stints, we try to engage in visitation through letters, et cetera, like that. There may be different programs. If we know a parent's only going to be in for, say, 6 months, there are programming that we can put on the case plan for them to do. But if someone receives a sentence of, let's say, 20 years, there would be no reason to put on there those objectives. The parent's not going to be able to do it. And then we're also putting ourselves out there that now we have to help them do these things that we know they can't do. And then we'll just be back in court with them saying, well, you said I could do this and you were going to help me do it, and then you didn't help me do it. And unfortunately, that's kind of the cycle of the way that it goes. It's often counterintuitive to me the way it comes back.
Thank you.
Thank you.
Thank you. I'd like to address a few things that were mentioned by the prosecutor here. First thing is, mother agreed to the objective of the child's basic needs need to be met in the case plan. However, she did not agree to her not being, or there be no objectives for her on the case plan. And there's journal entries that stated that mother did not agree to there being no objectives for her, and she's objecting to the case plan being adoption. So she didn't necessarily agree to the full case plan. She did agree that the child's needs need to be met. The second thing is I believe her judicial release motion was withdrawn at the time of the hearing, although since then she has reapplied for judicial, and it's not part of the record, but she had a phase 1 hearing last month, and she is in order to be brought back to phase 2. She took it upon herself without there being any objectives for her on the case plan. There's testimony regarding this at the date of the hearing. that she has completed sex offender treatment, she's taken parenting classes, substance abuse classes. She has taken it
All
upon.
that's in this record.
Yes. It was part of the hearing when the case plan was adopted. So she did testify, she was present at the hearing and she did testify that she took it upon herself and has taken all that programming while incarcerated. So in spite of there being no objectives, she did try to and manage to take advantage of a lot of that while she's been incarcerated. And she was never given an opportunity to put on the record what she was convicted of, what she was charged with, because we didn't have notice that this reasonable efforts was going to be even addressed at that hearing. The court on its own decided that CSP did not need to make reasonable efforts. Had we had notice, we could have provided the indictment, we could have provided more journal entry or testimony, but we didn't have that opportunity because we weren't even able to cross-examine the caseworker as to what his understanding was of what he was convicted. And the journal entry is silent as to what section she was convicted of or pled guilty to. So she didn't really have that opportunity. So that's why we're arguing that due process rights were violated. And in fact, there's testimony that the caseworker testified that he had not had any contact with mother. He did not know where mother was. And his legal department had advised him to file the case plan in that way. And that is on the October 3rd, 2013 hearing, pages 12, 19, and 20. So I don't believe CSB even attempted to figure out what could have been put on the case plan for mother to do, considering he said he didn't know where mother was at. And it's really not difficult to figure out where a defendant is incarcerated. It's all available online. So those are a few things I wanted to clarify. If there's no more questions, I would address in brief.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. Thank you, counsel. We are adjourned until Thursday in Summit County.